Blaine Redburn versus Dorma Redburn. You're on for a motion to modify the temporary orders that were issued in this matter.
Correct. Yes.
And Mr. Biddle, you filed that motion. Any announcements before we get started?
I don't believe so.
Mr. Pike?
No, Your Honor.
Okay, go ahead, Mr. Biddle.
Yeah, Your Honor, in this matter, temporary orders were entered on December 2nd regarding the parties' assets and child support. And one of the assets is $50,000 that's sitting in a savings account. That was a part of a medical malpractice settlement that was received by my client. And the order on December 2nd was that neither party shall access the $50,000 in her savings account with prior court approval. Since that time, one of the medical providers that had not been paid, and there's several, had a judgment, and the respondent's wages were garnished by Logan County Hospital for medical bills owed by the family in the amount of $3,919.02. That's the amount owed. They garnished her paycheck $963.08. And what she's asking, because she's out that money, is that she be able to access $2,955.94 to pay off the remainder of that judgment so that they stop garnishing her wages, and that she be reimbursed from that account in the amount of $963.08 pending further order of the court, so that she can recoup her income. And that's the basis of our motion.
Yes, Your Honor. That's we are unclear at this point what that medical debt was for. My client has been paying that bill off since 2020 off of his flex account, health savings account, until it was depleted, and that's why it kicked into garnishment at this point. But we don't have any. We know that some of this medical debt was for a daughter, Haley, and we're very worried about depleting this $50,000 any farther than it's already been depleted. There's been about over $75,000 to $80,000 already spent since Norma left the household, that we really have no idea where it went. We know there was a house bought for $35,000 that she's living in, and then the additional $40,000, we don't know what it's been spent on, and we're very concerned about any further depletion of any marital assets.
Not denying that the medical bill exists.
No, Your Honor.
Okay, and that's something that needs to be paid. It has to be considered by the court in the obligations of the parties.
Correct, and it would be considered in the final settlement.
Anything else, Mr. Biddle?
Nothing further at this time. Thank you.
Anything further, Mr. Pike?
No, Your Honor.
Okay. Well, it's reasonable to use the money to pay off debt, and to that extent, the court will allow it. That will be a consideration that has to be made, and a decision that has to be made when we go into division of assets and debts as to who incurred the bill, whose primary responsibility is the bill. Is it a marital debt? We'll consider all that at the time of the divorce. But both parties acknowledge that the bill needs to be paid, and let's get it paid and reimburse Norma Redburn the amount she was garnished.
I'll prepare a journal entry. Thank you.
Anything further today, Mr. Biddle?
Nothing from the respondent. Thank you.
Anything further today, Mr. Pike?
Yes, Your Honor. We would request that once this bill is paid, or, we would pray the court would have the remaining $50,000 be put into a trust account to where, neither party has access to it until, till final resolution of this.
Well, I think the court has already entered an order ordering the parties not to spend that money without court approval.
And we've complied with that order, and of course, that's why we filed our motion to get the court's approval.
Okay. Why would that not be sufficient, Mr. Pike?
Because we don't have access to that account, so we have no way of making sure that accounts that they haven't been deteriorating or being used. We're just taking them at their word, and this is becoming more tumultural every day. So I think it would just be a good idea to secure those funds, and then everyone knows where everything's at.
And if that's a concern, we can certainly send him a statement at the time of the last court's order, and a statement once the reimbursement is made, and let him see the account.
Now, the court has ordered that money not be spent out of that account without court approval, and that should be sufficient to preserve it. And Mr. Biddle understands the obligations. So, other than what the court has authorized today for the reimbursement of the garnishment and paying off the rest of that bill, which the court is not making any judgment today on whose obligation that is. We're just getting it paid right now. No further expenditures from that savings account without court approval. Okay?
Yes, Your Honor.
Okay. And obviously, at the time, Mr. Biddle will provide a copy showing what went in and what came out of that account as part of discovery. Okay?
Yes, Your
Thank
Honor.
you.
Okay. Anything further then, Mr. Biddle?
Nothing further. Thank you.
Mr. Pike?
No, Your Honor.
Anything else for the record today, Mr. Biddle?
Nothing further for the record.
Anything else for the record today, Mr. Pike?
No, Your Honor.
Okay, Mr. Biddle, you'll do the order.
Yes.
Thank you.
Your Honor, we're here just for a motion to add arrears to an income withholding order. We actually have been in contact with Mr. Bryan, and he actually gave us his last employer. So I'm not sure if he has objection to this or not, but we had requested $577, which is the current amount, plus an $87 for arrears, which would bring it to $664, $665 per month. And that would get his arrears down within a 3-year payoff. Like I said, this kind of came up. He had a change of jobs, and we weren't aware of it. And then he contacted us to advise us of the change of jobs. And then I think he had a second change of jobs, and he also contacted us to advise us of that. So that's what we're requesting today. We've already sent the income withholding order out. That came out in December. So.
Mr. Bryan, any objection to that?
No objection, Your Honor. May I proceed?
You may.
With my previous employer that we set up child support through, there were earnings that I was getting through that employer that I am not continuing to get through my previous employer or this current employer. Those earnings are a substantial amount to my annual income, meaning I don't know how much in percentage. I can't give you a percentage. The last time that I was working at Schilling, that fiscal year, I think I made about when we set up child support, I think I made about 13 to 15,000 just in per diem, and I'm not receiving any of that payment from this employer that I'm at now. My question was, is there something that we have to go through, because I have my own house, I have my own bills. I'm struggling to make ends meet because I don't make near the amount of money that I used to. And I'm limited to hours now. I don't get, the only reason that I was making that amount was because of that per diem, and I was getting 60 to 80 hours every week. I'm limited to 40, 50 hours now, and I just want everybody to know it is a struggle.
If you're wanting to request the court to look at your income and request a modification, you need to do two things. One, you need to provide all that information to Ms. Grabby so she can also share that with Ms. Mosley. Two, you need to file a motion with the court to modify your child support.
Okay.
But
Okay.
if you provide all of your income documentation to Ms. Grabby, and she'll tell you what all she's going to need,
Okay.
then the parties can look at it. If you're all in agreement, you can submit an agreed upon order. If not, you'll need to file a motion and ask the court to take that up as an issue in a future hearing.
Yes, sir.
Okay?
Yes, sir, Your Honor.
Ms. Grabby, anything further to add?
Your Honor, I would just tell Jacob I can send him modification paperwork, and we will file that modification motion if it's eligible for modification. So we can send that to him if he wants to request that. I can send it to him. I can have Molly send it to him today.
Yes, if you would, please. Do you want my email now, or?
Well, wait
No.
till the hearing is over. I will jump off. Once I jump off, then we'll stop broadcasting, and then you
Okay.
and Ms. Grabby can communicate, and you and Ms. Mosley can communicate without broadcasting that personal information, okay?
Okay.
Okay. Any further issue or anything further for the record on today's motion, Ms. Grabby?
Nothing from me, Your Honor.
Mr. Bryan,
Nothing for me, Your Honor.
Ms. Mosley?
No, Your Honor.
Okay. And Ms. Grabby, you'll do the order?
I will do the order.
Great. Okay, I'm gonna jump off and you stay on just a little bit, Mr. Bryan, and then you and Ms. Grabby and Ms. Mosley could speak, okay?
Okay. Thank you, Your Honor.
Okay, thank you all.
We were here, I think back in August, we had Ms. Sokol personally served. She appeared at a hearing, and she made a payment back in September, and then another one in November. We did not get a December payment, but we had contacted her, and she had called us back, and I think she had been talking to my assistant Molly. It sounds like she's had some unfortunate happenings occur over the New Year's holiday. I think you can see her hand there. But she's indicated to our office that she can get that payment made by between 2 and 4 p.m. today. So I would just inquire if that's still the case, Your Honor. And then I would probably just ask for our general language, which is the 10-day bench warrant language, asking that that payment be made within 10 days, or we'd be allowed to issue that bench warrant with a cash bond that would be applied. And then reset it for the next month in February.
Quantity of the cash bond you're seeking, same as last hearing?
Yeah, same as the last hearing. I think it was probably
It's $350.
350.
$350, I think, is the amount of the payment.
No, 342 is the amount of the payment.
Okay,
I thought it was a 500 cash bond.
and it was a 500
It
cash
might have
bond.
been. I didn't pull that up.
Yep. Per the order of September 30th of 24. That was filed September 30th. The order is from September 4th of 24. Ms. Soko, you understand what Ms. Grabby is requesting?
Yes, Your Honor.
Are you able to make your payment today?
Yes, Your Honor.
Okay, if you don't make a payment today, her office will be checking on Monday. You understand that?
Yes, Your Honor. I was informed to send the receipt to an email address that I'll send today for confirmation.
But if you don't, if Ms. Grabby's office has not received proof, come Monday, they'll be requesting a bench warrant. You understand that?
Yes, Your Honor, I do.
Okay, and same as the September 4, 2024, the court will issue a bench warrant in the amount of $500.
Okay.
That's cash only, and that would be then forfeited towards your obligation.
Okay.
Okay?
Yes, Your Honor.
Anything for the record, Mr. Reynolds?
No, Judge, no objection to the request.
Okay, anything else, Ms. Grabby?
No, Your Honor. I think Bobby and Molly have been in contact, so I think Bobby has the email address. I think she's previously sent us a receipt copy. So, Bobby, you know, if you have any questions, you can call our office.
Awesome. Thank you.
Okay, anything further today, Ms. Grabby?
Nope.
Anything further today, Ms. Solko?
No, Your Honor.
Anything further today, Mr. Reynolds?
No, Judge, thank you for the court's time.
Okay, thank you all, and Ms. Grabby, you'll do the journal entry?
I will. Mr. Reynolds, do you want a copy to you, or am I okay to put your e-signature on it? It's going to be our general language that we do almost every hearing, but you're welcome to review it if you want to.
Yeah, I'll do a quick review and get it right back to you if you don't mind.
Sounds good. Yep.
Thank you.
Yep.
Okay, thank you all,
Thank you.
Thank you.
and we are adjourned. You're on for our review. Have we made our payment?
Yes, sir. There was a payment made of 400 by the 10th. That has posted, and therefore I'm just going to request that we have that continuing order to make 400 by the 10th of each month. If none is made, that the bench warrant would issue with the cash bond of 1,500 to be applied to the child support obligation, and that we continue this out to the January date, somewhere 24th or past, via Zoom.
All right, how are we doing on the arrearage? This is all arrearage, I understand.
So we are the obligation is no $275 a month, and then the arrearage, any extra is going to arrearage. So for the last we've gotten payments, so we have made some headway on the arrearage. We're currently at $11,412 in arrearage.
Okay. Okay, well, the order will continue that you need to pay by the 10th of the month. She'll check on the 11th. If it's not receipted, she'll request and the court will issue the bench warrant. You understand that?
Absolutely, Your Honor. Absolutely.
Okay. Again, I would encourage you, if you could get yourself a month paid in advance, that would make your life a lot easier.
I believe so. I believe you're right, Your Honor. Christmas this month made it a little tough. I was hoping that I'd be able to pull in a little bit more, but with Christmas right here, I hope to next month for sure.
Okay. Any objection to proceeding as we have been, Mr. Luttrell?
Absolutely not. That's fine with me, Your Honor.
Okay. Anything else for today, Miss Grabby?
Just resetting it for January. I'm sure your schedule is packed. So just to see what we could get for January.
Jess will squeeze him in. She'll find 15 minutes for us. Okay, January 27th at 2:30, Mr. Luttrell.
Sounds perfect, Your Honor.
Miss Jacobs.
That works for me.
Okay. We'll get together on January 27th at 2:30.
I'll send out a journal entry, Your Honor.
Excellent. Anything else for the record today?
No, Your Honor.
Miss Grabby,
None for me.
Miss Jacobs,
Nope, nothing.
Mr. Luttrell.
No, Your Honor.
Okay, thank you all.